From Neural Newscast, I'm Noah Feldman.
And I'm Thatcher Collins.
The legal landscape for American trade shifted dramatically today, following a major Supreme Court decision regarding presidential authority. The court struck down a core component of the administration's trade policy, specifically the use of the International Emergency Economic Powers Act to impose sweeping tariffs. This ruling effectively invalidated the reciprocal duties and drug trafficking-related tariffs that have been a cornerstone of the White House economic strategy.
The majority opinion in this 6-3 ruling was quite clear. The justices determined that the IEEPA does not actually authorize the president to impose tariffs. It's a significant rebuke, especially considering that the majority included two of the president's own nominees, Justices Neil Gorsuch and Amy Coney Barrett. During a White House briefing, Trump expressed sharp disappointment in the ruling, even going so far as to criticize the justices personally.
It's a heavy blow for the workforce initiatives we've been tracking, as the administration argues these tariffs are essential for rebuilding the domestic manufacturing base. Trump was adamant that he won't let this ruling slow down his agenda. He insisted that he has the right to set tariffs and doesn't need to work with the legislative branch to do so. This set the stage for a very rapid policy pivot that we saw just hours later.
That pivot involves a new executive order that, Noah, the administration is using to effectively replace the struck-down duties. Trump announced he is signing an order to impose a new 10% global tariff. This time, he is invoking Section 122 of the Trade Act of 1974. It's a different legal mechanism entirely, intended to bypass the limitations the Supreme Court just highlighted.
The use of Section 122 comes with some very specific constraints that the previous IEEPA tariffs didn't have to navigate. For one, these new duties are legally limited to a 150-day window. If the administration wants to extend them beyond that, they would need to get congressional approval. Trump seemed dismissive of that time limit during the briefing, stating that the executive has the right to do what it wants, but the law is quite specific on that duration.
Noah, there's another technicality here. By statute, Section 122 tariffs must be non-discriminatory. This means the U.S. can't easily grant specific exemptions or breaks to certain trading partners while applying the rate to others. This is a significant change from the flexibility the White House enjoyed under the Emergency Powers Act. However, the administration is also launching several Section 301 investigations into unfair trade practices, which could eventually lead to higher, more targeted duties on top of this 10% baseline.
While the legal team maneuvers through these statutes, Treasury Secretary Scott Bessent is working to reassure the markets. In a speech earlier today at the Economic Club of Dallas, he mentioned that using these alternative laws will keep tariff revenue virtually unchanged for 2026. He was very firm that no one should expect the revenue to go down, despite the Supreme Court's intervention. This suggests a very aggressive effort to layer different laws to maintain the current fiscal trajectory.
The immediate impact on international partners is going to be complex. For China, the White House indicates that these new tariffs will replace the invalidated IEEPA duties. When you combine the new 10% global tariff with the existing 25% duty that remains in effect, China is looking at a total rate of 35%. That's a massive number for any supply chain manager to factor into their 2026 projections.
The situation with the European Union is even more interesting. The EU had previously agreed to a 15% tariff as part of a trade deal with the U.S., but because those tariffs were largely implemented under the now invalidated IEEPA, they've been struck down. Since the new Section 122 tariff is currently set at 10% and must be non-discriminatory, some of those countries might actually see a temporary reduction in their U.S. tariff rates.
That creates a strange irony where a court ruling intended to limit the president's power might actually force a lower rate on some partners in the short term. But the administration is already looking at other tools. Jamieson Greer, the U.S. trade representative, noted that more announcements are coming in the weeks ahead to ensure continuity in the trade program. They're clearly looking at every available statute to keep the pressure on.
For the domestic manufacturing sector, this volatility is the primary concern. We've already seen small furniture retailers and other businesses expressing existential worry about how these shifting rates will affect their inventory costs. Even though the Supreme Court gave them a brief moment of hope by striking down the original duties, the immediate replacement with a new global tariff means the high-cost environment for imports isn't going away.
I'm Noah Feldman.
And I'm Thatcher Collins. Thank you for listening to Neural Newscast. Neural Newscast is AI-assisted, human-reviewed. View our AI transparency policy at neuralnewscast.com.